A federal Capital Territory High Court, on Tuesday, rejected the bail application of former Kogi State Governor, Yahaya Bello, citing procedural irregularities in the filing of the application. Justice Maryanne Anenih, while delivering the ruling, stated that the application was premature as it was filed before Bello was present in court or in custody. The judge said, having not been filed when the first defendant was either in custody or before the court, this instant application is incompetent. Consequently, the application, having been filed prematurely, is hereby refused. Bello, alongside 2 others, is facing charges brought by the Economic and Financial Crimes Commission over an alleged N$110 billion money laundering case. The court noted that the bail application, dated November 22, was filed before Bello's arraignment, which took place on November 27, days after he was taken into custody on November 26. Recalling the arguments before the court on the bail application, the judge had said, "Before the court is a motion on notice, dated and filed on the 22nd of November. The first defendant seeks an order of this honourable court admitting him to bail pending the hearing and determination of the charge." Bello's counsel, Jacob Dowdu SAN, urged the court to consider the application, arguing that his client, a 2-term governor of Kogi State, would not interfere with witnesses or jump bail. The first defendant became aware of the instant charge through the public summons. He is a responsible individual and will abide by the conditions set by the court, Dowdu argued. He urged the court to exercise its discretion judicially and judiciously to grant the bail. However, EFCC counsel, Kemi Pinheiro SAN, countered that the application was grossly incompetent, as it was filed before the arraignment, contrary to the provisions of the Administration of Criminal Justice Act. In opposing, the prosecution counsel, Kemi Pinheiro SAN, had argued that the instant application was grossly incompetent, having been filed before arraignment. He said it ought to be filed after arraignment, but the first defendant's counsel disagreed, saying there was no authority that says that an application can only be filed when it is ripe for hearing. Pinheiro emphasized that the timing rendered the application invalid, urging the court to dismiss it. Meanwhile, the second defendant, Umar Orica, was granted bail in the sum of N$300 million with 2 sureties. The court specified that the sureties must own properties in Abuja's Maitama district valued at no less than the bail bond and must submit the original title documents to the court. Justice Anenih further directed that the sureties must depose to affidavits of means and submit copies of their international passports to the court. Orica is to deposit his travel documents with the court and remain in custody until all bail conditions are met. While delivering her ruling, Justice Maryanne Anenih said, "The instant application for bail showed that it was filed on November. This shows that it was filed several days after the first defendant was taken into custody." Reading from the ACJA section, the judge said the provision provided that an application for bail could be made when a defendant had been arrested, detained, arraigned, or brought before the court. The magistrate court in Ado-Ekiti has denied bail to human rights activist, Dele Farotimi, in the suit filed by the Inspector General of Police, Mr. Kayode Egbetoken, against him over alleged cybercrime. Farotimi was taken to court for allegedly defaming the founder of Afe Babalola University, Ado-Ekiti, Afe Babalola. Earlier, the police in Ekiti State, following a petition by Babalola, arrested Farotimi in Lagos and arraigned him before an Ekiti State Magistrates Court in Ado-Ekiti last Wednesday on charges bordering on defaming the elder statesman. The magistrate, Obayemi Adeosun, ordered that Farotimi should be remanded in the correctional center, while he adjourned till December 10 to hear his bail application. At the court hearing on Tuesday, the presiding magistrate, Obayemi Adeosun, postponed the decision on the bail application to December 20. This happened after the police counsel, Samson Asobu, argued that the bail application submitted by the defendant was incomplete and not properly filed. This ruling, however, contradicts the decision of the Federal High Court in Ado-Ekiti, which granted Farotimi bail on Monday. Farotimi was arrested in Lagos by the police and transported to Ekiti, where he appeared before the magistrate court on Wednesday. He was charged with defamation stemming from statements in his book, Nigeria and Its Criminal Justice System, where he alleged that Babalola had compromised the Supreme Court. In his ruling, the Chief Magistrates Court in the Ado-Ekiti Division ordered that Farotimi be remanded at the state's correctional center. Farotimi's arrest has, however, sparked public outrage. The 2023 presidential candidate of the African Action Congress, Omoyele Sowore, called for his immediate release in a post on his X handle. Sowore stated, "It is pertinent that the Nigerian police are notified that the institution cannot continue to be used to settle personal scores, and we, the citizens of Nigeria, would no longer tolerate such a situation. Therefore, the police at Zone 2 in Lagos are advised to release Barrister Dele Farotimi immediately." Also, a senior advocate of Nigeria, Femi Falana, also condemned the arrest, describing it as illegal. Falana demanded Farotimi's unconditional release, stating, "The arrest is unlawful and we demand his immediate release from police custody." It was learned that Peter Obi had visited Afe Babalola for an amicable resolution, while still on the same course visited Dele Farotimi at Ado-Ekiti Custodial Center.